We're going to do confidences, and then next week we'll do a short bit on attorney-client privilege, probably cover this overall, so we'll hit it, but not going to hit it hard. And then we'll start the chapter after that, start leading us into more of the components of the attorney-client relationship, and then that will move us into conflicts, and we'll spend a great deal of time there. So you notice throughout the course we have been focusing on the essential aspects of the attorney-client relationship, and one of the most essential is Rule 1.6. And really, the attorney-client relationship really flows from that trust, that candor, that collaboration between the attorney and client. And the only way we get that is if the client is confident that we will protect and safeguard those secrets. So we don't want to divulge information that would undermine our client's interest. And so even when we were talking about lawyer liability towards the end of the chapter 2, we were looking at protecting those confidences. We did the little hearing, that's problem 2.3 on page 86. And we looked at competency, we looked at can the senior lawyer say that this is a reasonable resolution of a professional duty? We said no. And then is there a duty to report? And so we noted in real life the student never did report the misconduct and moved on. The professor didn't either because this was given in confidence. And so that's one of the problems that you have in real life practice. These things occur and you sort of have to address them. But in a real world situation, this attorney did not report it, moved on and got another job. And we can't really say that this is a reasonable resolution of any arguable question of professional duty. Here you have large-scale litigation and an attorney who's essentially rationalizing incompetent representation. And we noted the problems with that. From there, we went on page 90 to legal malpractice. That's civil liabilities of the attorney. Professional misconduct, allegedly causing harm to another, that's malpractice. And we noted on the top of page 91 that these actions can be styled a number of ways. There's usually a tort action, a contractual action, and a fiduciary duty action. Those can be brought separately or brought together. We know that attorneys have the utmost expertise and trust with their clients, so we have a fiduciary duty. But the basic malpractice claim is a duty, failure of competence, that's the breach, and then breach of that duty. That is the most difficult component to prove because that's the case within a case. You have to show that the lawyer's negligence or bad conduct actually caused the harm. So that's easy, like in the statute of limitations case. That would never happen to you, of course. But say that the statute ran and then a potential claim is dismissed with prejudice, can't file it again, it's just lost. That would be injury to the client. But notice how difficult that might be to prove. You could say, well, this claim went away, and then the client would say, well, I would have won $1 million if we had won. So that would go back and forth because even though there's an injury, that injury might be speculative. So that just illustrates the difficulty of proving the case within a case. So we talked about that. Then on page 92, it's important. This is just something for you to think about. These are all of the areas generally where lawyers get into problems. You know, basic things like communications, that's under 1.4. If you don't return emails and it's been months and months, and then the client says, what's happening with my case, and you just say, I'm working on it and I'll get back to you, things are progressing. That's not communication because we want both the client to be informed and to be able to meaningfully help this transaction or litigation or matter move forward. So communication is one. Settling a matter without authorization from a client, you know you have to communicate with the client and have common goals. That's why, Rule 1.2 is important. That talks about scope of representation. so the attorney and client are both on the same page. So we looked at that. And then that was pretty much the end of that chapter. Finally, on page 100, there's just a number of different things emphasizing the point that along with these model rules, we are impacted by other law. So we have our ethics code, of course, which is the Kentucky Supreme Court rules that we will be dealing with, pretty much the same as the model rules, but you'll check that as you're practicing. We have disciplinary law, ethics opinions, malpractice law, that's a body of law, disqualification law, when someone brings a motion to disqualify a firm based upon a conflict, that's a body of law. You have to look at criminal law, court rules, and regulatory law. So there's a body of other law that governs our conduct as well. Then we moved from chapter 2 and went into chapter 3, confidences. 1.6, very important rule. So we know we have this basic prohibition against divulging client confidences. Lawyers shall not reveal information relating to the representation of a client. We emphasize how relating to the representation is very broad, broader than those privileges and confidences that we talk generally that arise out of a litigation or some type of subject matter. This is broad. Anything we learn from the client, anything that we learn in the outside world that could be deemed confidential, we shall not disclose that. But even within that context, there are some exceptions. One, the client can give us informed consent. Yeah, this is really sensitive information, but in order to move this matter forward, I give you consent that you can divulge this information. Informed consent means that the client fully understands the tactics, means, and consequences of taking this course of action. It's not just, can I do it? Okay, and now I'm going to do it. So that's informed consent. The disclosure could be impliedly authorized to carry out the representation. You're worried about a potential conflict on the horizon. And so in order to get information or guidance on this potential conflict, you have to divulge some confidential information. That would be fine. Probably check with the client even though it's impliedly authorized, but that is what you would need to do in order to move the representation forward. But we have this broad prohibition, and then we have a number of exceptions. And we'll go through those exceptions, but there are about 7 exceptions in terms of confidentiality, and we had started talking about those by applying it to the cases, the missing person. Before that, on page 105, we did Your Dinner with Anna. That was just a scenario where we talked about lawyers are normal people, they have conversations, but you just have to be careful that you don't divulge too much. So after you get past the name of this potential client, you don't give the last name, the bar, and then the more information you give, the worse it is because you could lead to confidential information. And pay close attention to comment 4 to Rule 1.6. That's important because it says you may be talking about something that isn't even confidential, but it could lead to confidential information, so you have to be very careful. So if you look at comment 4, it says this. This prohibition also applies to disclosure by a lawyer that do not in themselves reveal protected information, but could possibly lead to the discovery of such information by a third person. So you have to be careful. Yeah, this may even be public information, but you have to weigh context and what this information could lead to because it still could undermine protecting the confidences. Then we started with this real case I told you about on page 120, the missing persons. And what we did there is in problem 3.2, we looked at all of the options. What do we do in this case? We have mass murderer. We know where the bodies are probably. What do we do? Do we reveal? Do we visit the site? Do we do nothing? And we looked at whether or not we could disclose under Rule 1.6b1. And we agreed really there's nothing to prevent. And so we would probably just continue to represent the client. We also looked at, does this public health law compel disclosure? And we said, no, not really. That's not the type of law that would compel disclosure. And if you look at comment 12 to Rule 1.6, it really doesn't resolve the issue. It just says whether that law supersedes 1.6 is a question of law beyond the scope of the rule. But we know that something like a public health law, at least in this particular case, did not allow the attorney to disclose. And we have those two cases that point that out. People versus Bells, that's the trial court opinion on page 126. The indictment against the attorney is dismissed. And he's acquitted because the duty to protect privileged information trumped the duty to report. So we're not going to allow the attorney to undermine any of the criminal defendant's privileges. And then finally, you see on page 128, the appellate division affirms, concluding that the trial court properly dismissed the indictment. But we raised the point that this did not really get to the ethical questions. All it really looked at was sufficiency of evidence, and it says, we believe the attorney-client privilege effectively shielded the defendant attorney from his actions, which would otherwise have violated the public health law. So just affirming that there's no disclosure here. We're not making a determination about the ethics of it, but having this absolute attorney-client privilege raises some questions that the trial court doesn't answer. That's on page 129. Now, I don't think we did problem 3.3, did we? The missing persons? We didn't finish that up. Okay, so leading into that, this is on page 129. You have a couple of questions sort of leading into the third version of this problem. We did not report because we have this duty to stay, to preserve client confidences. That was good. Then when we went to the second level problem, we looked at what is the best option. We chose option 3. Don't share the information, get a prosecution some information, prosecution gets angry, and then we looked at those two cases. So on page 129, we're looking at problem 3.4, the missing person. But before that, you have this. Is this obstruction of justice? It's on page 129. And it changes the facts. It says this. Suppose that New York's obstruction of justice law declared that corpses are essential evidence in homicide investigation. It's a crime for any person with knowledge of the location of a dead body not to report it to the police within 4 hours, because failure to disclose would be obstruction of justice. Now, would that be a situation where a court would hold that that type of statute overrides our duty to preserve confidence? So notice what the High Court does. It takes the public health law that the court said in the opinions, both the trial court and appellate court, takes that public health law, which was not enough to trump the duty to maintain these client confidences, and ties it to a more substantive crime like obstruction of justice. Do you think a court would rule that if you don't disclose as an attorney, that's obstruction of justice? What do you think? Should the courts hold that that this statute overrides an obligation to preserve confidence? Because you notice that the other conversation that we had about a public health law, we didn't have that much problem saying, well, this other law does not compel disclosure. It's just like a public health law, and we sort of thought that the prosecuting attorney was being vindictive anyway. So we had no problem saying attorney must preserve those confidences. But what if we take that public health law hook it up with an obstruction of justice charge, do you think a court will say, now that is the type of statute that overrides our duty to preserve confidences and you must disclose? Or do you still have the option, is it still may? Yeah. Yes, go ahead.
I don't know. I think like courts, some courts would side with you if you didn't disclose, and some would try to punish you for obstruction of justice. But I think the amendment would supersede the state law.
Okay, now tell me about that.
Well, I mean, you would be disclosing information that indicts your client.
Yeah. So that could be an argument, and even if a court says, well, this overrides it, this is obstruction of justice, we have this broad panoply of rights that we have to consider. We're the advocate, we're the counselor, we certainly are a officer of the court, but we also have to represent our client's interests. And it would seem counterintuitive for a lawyer to be able to turn on his client just to comply with a statute here. And you can also say these rules give us some guidance, but not enough, because comment 12 just says whether or not a rule supersedes the duty not to disclose is a question beyond the scope of the rules. So that really doesn't help the attorney. But I think always the first inclination would be to fight disclosure, because we have this mandatory duty. And also, if you look under 1.6b, 6, to comply with other law or court order, you have the discretion to make some type of determination about whether or not to comply. I mean, the language is may. So, what about this last stretch of the problem? Problem 3-4. I might have said 3-3. 3-4 on page 129. The missing person, scene 3. So we've come out of this way. We know that we have this duty to preserve our client confidences. We know that there's some exceptions. We noted that the public health law does not trump our duty to preserve these confidences. And so this final version of the problem sort of gets at how we exercise our discretion. Which is interesting, because remember all of the exceptions talking about may. So here we have a situation where it looks like our former client is threatening us. You look on page 130. It's clear that Garrow escapes and he's looking for us. That's the attorney. What do? Do we preserve this confidence?
It's just an unfair situation. That's just an unfair situation because now...
Unfair?
Well, what I mean is, like, in theory, you may still have an obligation to protect those confidences, but at the same time, it's not just somebody else's life anymore, it's your own life.
Right.
So it's, now you've got your own, like, self-preservation and self-interest that are in the mix.
And other people too, yeah. So would you have a problem telling, or what would you do?
I mean, I don't know if I don't think there's an actual rule that like allows for you to actually the first
You're on a hit list.
then
I mean, it's an
I would
and
hope
he
that the
escapes.
first
And you know where he hides out.
I would hope that the first exception would apply then, because if that knowing that he has killed before and it is substantially certain that he will kill again if he's out, that means that all those people on that list are in immediate danger. So I would hope that the first, that, 1.6B1 would apply to prevent like certain death or substantial bodily harm.
Yeah, but see, and then what about this though? The rules really doesn't tell us how imminent it should be. How close does the criminal defendant have to be for us to say, okay, now I can disclose? And I'm getting at this, that the examples that we get in the comments to the rule talk about dumping in the Ohio River or something like that, and that's imminent to prevent substantial bodily harm. How do we know when it's imminent enough to disclose?
You want to wait for the first body to show up? Because I don't. I would think that in that situation, based on the past, based on what has happened before, that would be how you determine, okay, exactly how likely it will happen.
That's okay. And
based on his record,
yeah,
it's likely to happen, so I would disclose.
And my life is on the line too, and other people too. Ms. Hernandez, did you have anything?
I was just going to say, I think it would count to prevent.
Say it a little bit loud.
I think that the exception to prevent death or bodily harm would definitely count.
Yeah. I mean, it's particularly compelling though when it's you though. Think about that. It's like, well, you maybe tell, if you think there's a risk to others, that's great. You give knowledge about Garrow's previous crimes, as you pointed out. 1.6 would permit but not require, but you have the power to make that determination. Continued loyalty to the client, how far does that go when your life is on the line? And so we have this exception that's really based upon the social importance of reducing the harm to other people. And really, you could also say there's no such thing as undivided loyalty when the lawyer's life is threatened. I mean, how can you be loyal with that hanging over your head? So, what do you think happened in the real case? This actually happened. He escaped.
Wow.
You think the lawyer said, I'm going to preserve the confidence of something noble? Yeah. What do you think? What do you think happened? Think he told? Oh yeah. Definitely told. Because notice this is interesting. This was a confidence, and you're the attorney. He gives you all of this information, so he gives the attorney this secret hideout. Probably nobody would have found it unless the attorney told. The attorney tells the police find Garrow. They have a gun shootout, and he's killed in the gun shootout with the police. So, the book on page 131, I want to make this point. So this is just a practice point, and you're going to do this whatever jurisdiction you're in. You're going to look at these things. You're being tested on the model rules of professional responsibility, both in this class and on the NPRE. But you also have to look at, so if you're practicing in Kentucky, you're going to look at the Kentucky rules of court. And our rules are the same, with the exception that we only have 4 exceptions. So Kentucky has made the decision that we really want attorneys to protect these confidences. And so the ones that we have here in Kentucky is 1.6A is the same, and then it says a lawyer may reveal information to prevent reasonably certain death or substantial bodily harm. That's good. We don't have 1.6B2. This notion of substantial injury to financial interest. Now that may be taken care of with another section anyway, because we know that you can't assist the client in fraud or criminal conduct, but we don't have the substantial financial interest component. We do have, if you want to secure legal advice about compliance with these rules, and then establishing a claim on behalf of the lawyer. Defense, protecting yourself in a ethics proceeding, and then to comply with other laws. So there are only 4 exceptions. This is a Supreme Court rule. So 1.6A is the same. And then we have the 1, 2, 3, 4. I'll just put certain death. So in that escape hypo, we could do that in Kentucky. We have that discretion. Keep in mind again, these exceptions are may. Secure legal advice about compliance of what? And then we have establish a claim. Or comply with other law. So kind of the same but narrower exceptions because we really want to emphasize this notion that attorneys should preserve their clients' confidences. Now, the exercise of this discretion seems kind of weird. Because notice, there's no way to really have uniformity in terms of the way that the attorney exercises his or her discretion. For example, we just get this series of problems where the attorney would not tell the location of where those bodies are, preserve those confidences. But what about a little bit later on, you haven't been paid for this, all the work you did, and you're owed about $100,000, and you have a choice. You preserve the confidences in terms of the litigation itself, and everything's over with, but you still haven't gotten paid. And there are some confidences that you may have to reveal in order to get paid. Maybe the client says, no, you didn't do that for me. There was not even a claim about that, so I dispute that. I don't owe you anything. And that's something Garrow will probably do. Now, you have done everything you can under the rule and done the right thing. You preserve the confidence. Would you reveal the confidence in order to get paid? You can do that. But would you?
He's dead now?
I'm sorry?
Are we assuming that Garrow is dead at this point? Like this has happened after the shootout?
Oh, yeah. All of this. He could be alive or dead or the shootout or whatever. You want to get paid. You have a decision to make. You have kept the confidences up to this point, but you're owed $100,000, and probably the only way to get them is to talk. Now, when I say reveal the confidence, I don't mean to take the entire case file and say, here are all the confidences, now give me my money. You have to be only disclose what is necessary in order to receive that payment. So you have some discretion there. Yes, go ahead.
I would look at the likelihood of actually their ability to pay me, and actually pay, because they're probably going to file the countersuit or something with the bar association if you basically sue them to get paid. So is it, and then how much do they owe? Right? If it's the minimum amount of money, then it's probably not worth something on your bar record or.
Right. Well, that's why I made it $100,000. And let's say we know that there's some relative or somebody in Garrow's family who definitely could pay. So in one instance, we said we're not going to divulge it. We're protecting our client. but we do have the discretion. We don't have to, but we do have the discretion to say, look, if I don't get paid, I'm gonna have to do this. This is the only way I can establish this claim on my behalf. So what do you think? Yeah.
So the first question that comes to mind is my reputation worth $100,000?
Yeah.
Like, if I'm gonna lose, like, maybe possible future clients if word gets out that I'm taking this stream.
Mhm.
But then again, like, you have to eat too. Like, if it's like my firm maybe is like in dire need, like I'm a, private practice, like this
Mhm.
is how I eat. Like, yes, I have to feed my family.
Mhm.
Tough decision.
Yeah. So how would you resolve it then?
Probably
You
wouldn't do
wanna
it.
do it? Okay. Yes, go ahead.
I just have more of a question. Like, I don't know how this works really, but can you, I guess, like request or have like a closed hearing so you're not putting all their information in the public?
Okay. So you say like go in camera, sort of get a preliminary ethical opinion from the court itself. This is the only way I can get it. I need to dispose it, and then see what the court says, and then depending on what the court says, move on from there. Yeah, you could do something like that. Or you could reach out and try and get an ethics opinion. I'm sort of looking at this, look at comment 11 to rule 1.6. A lawyer entitled to a fee is permitted by paragraph B5 to prove the services rendered in an action to collect it. This aspect of the rule expresses the principle that the beneficiary of a fiduciary relationship may not exploit it to the detriment of the fiduciary. Which is a long-winded way of saying we want to get paid. We did all this work. Yeah, we have this this position of utmost trust, and you've given us all of this information, but you can't use that protection in such a way as it undermines our ability to be compensated as well. Yes, go ahead.
I can't find it, but didn't we read somewhere that if you sue a client for non-payment, you risk either a high risk or malpractice?
When you sue for non-payment?
When you sue a client for non-payment.
Okay, I see what you're saying. That was probably a sentence in passing that you may open yourself up for counter allegations that you didn't even perform the work appropriately. Yeah. But mine is a little bit cleaner. So assume that the attorney did everything. But what there is a dispute about is what services were rendered and how the lawyer should be compensated. So the lawyer did his work competently, but Garrow is saying, no, you didn't do that. We didn't even raise that defense, and how could you do that because you wouldn't even have that type of information. The attorney wants to say, yes, I did all of this, and this is the information that we use, and some of that information may be confidential. So I'm sort of making the hypothetical whether or not you will divulge that. You may, so I'm asking, would you? Some of you said my reputation is more important than $100,000. There are dangers when you initiate a action for payment, but it just points to how interesting this discretion is. We're going to see throughout these rules. There's another rule, 1.5, when we talk about fees. We have a tremendous discretion in how much we charge, and we have the power to try and get paid. So that may undermine some confidence at some time. But it's interesting that you can be sacrosanct in keeping the bodies hidden because of your duty and confidences. But when it comes to getting paid, you may exercise that discretion and divulge those confidences in order to get paid. Just another wrinkle about our lawyerly discretion. Now there's another case here that we're going to look at, and it is called rat poison on page 133. So notice and some of you said this, so I'll just sort of summarize. When we did a problem about the hidden bodies and over again, most of you sort of point to this proposition, and it's true. This is the tension that we're trying to negotiate. And it's this: a lawyer really should not be an informant on her own client. But we have discretion under Rule 1.6b to prevent harm. I mean, there's a decision made in these rules that what we really want to prevent is harm. And so rat poison is a example of that. This is on page 133. So we represent a client who has a small extermination business. And he has some mental challenges, none that will prevent him from doing his job, but it says he graduated from high school, and we assume that his mental capacity is normal, but sometimes he has judgment issues. But anyway, our client, Harry Norton, used industrial strength rat poison in residences, and a 4-year-old boy was killed, died because of that, ingesting the industrial strength rat poison. 4-year-old boy passed away, and then we have involuntary manslaughter, which is what Harry is charged with. Now, during our interview, we asked our client, has he placed this type of rat poison in other homes? He says yes, maybe 30 to 40 homes. He has a file with records on it, I guess, with the location in each of the houses. We urge him to tell, go through the box and then find all of the other homes and then revisit the homes and take out the dangerous rat poison. And so through the course of time, he takes a long time, and we're beginning to get worried because of this exposure. And you see on the top of page 134, we consider approaching the prosecutor to arrange an exchange of information about the location of the other rat poison, and for a promise that the prosecutor will not file additional charges against our client. Our client has been unwilling to allow us to approach the prosecutor to discuss this issue. And he keeps saying, yes, I'm going to do it. I'm going to revisit these former customers, get the rat poisoning out of there. Prosecutor hasn't done anything yet, so we still have some time. Prosecutor has not issued a warrant for Harry's records. We don't know why that is, but we still have some time. We're worried that Harry might try to, quote, solve his problem, it says, by destroying his records. You know, he destroys records and then he'll be able to say, I've never been there, I don't know anything about that. Criminal law in our state provides that any person who recklessly engages in conduct that creates a substantial risk of death or serious physical injury to another person is guilty of the misdemeanor of reckless endangerment. What should we do? What should we actually do? So we have a number of options. I'll put them on the board and we'll see what. And notice what we're doing. We're still sort of balancing our duty to preserve these confidences against exposing the public to some greater harm. So we have a number of options. We can contact the prosecutor. And avoid new charges. For plea bar. That's one option. Another thing we can do is go to the client's home. And seize the records. Now these are just options. I want you to sort of assess these because that's what you'd be doing in the real world. Don't worry about the rat poisoning. Continue to represent the client. Because you're exercising your discretion, you're saying may disclose. You don't know how imminent it is, what is the substantial injury that happened in the past. So you just would rationalize just moving on. Or go with Harry. To all of the homes and collect the rat poison. Or withdraw from representation. There you probably made some determination that there's some continuing harm because of this reckless endangerment statute, and the longer you stay on it, the longer you're exposing yourself to liability because on some level you're assisting the client's crime by not doing anything about it. But that may be drastic, withdrawn from the representation. What would you do here? What would you do? Yeah.
I think I would continue to represent but like consistently talk to the client about what I believe was the best course of action with preserving the records and contacting the other people to remove the rat poison that was still there.
Mm-hmm.
But I don't think the law that's cited in the scenario, I don't feel like that's specific enough or direct enough to the attorney's position in this case.
Okay, tell me about that. Why?
Well, it just says any person who recklessly engages in conduct that creates a substantial risk. I don't feel like the attorney is really engaging in the conduct. To me, it seems more like a stretch to kind of connect that to the attorney's actions of not disclosing that information. To me, I think could an argument be made for that? Yes, but I think the rules under 1.6 are more important than that law because they're more direct.
What about this? So you reject this sort of notion that the lawyer knows about this. We already have a child that died because of ingestion. These are continuing conditions in 30 to 40 residences, and if the client doesn't do anything about it and the lawyer knows, then that should lead to some type of liability? No?
I think prosecution knows the records exist but hasn't requested the records to address that issue either, and I think just continuing to, not to say that you could go off of the prosecutor's actions as your own, but I think that just advising your client that would be the best course of action, and maybe trying to steer them in that direction, and maybe they're just stubborn, maybe it takes a little time for them to want to do that. But I would continue to represent
that is certainly acceptable. I wouldn't disclose and just keep representing. But then, what are you doing about the time that is passing and your knowledge that these things are still in place and something else could happen? Do you have any worry about that? And then how would you resolve that as an attorney? In other words, on a totally rule-based level, you have done the right thing. You've preserved the confidences. You haven't exposed your client to further liability, but you know there's the possibility of substantial harm out there. And it's like ticking. And so, what do you do to manage that time? And notice how the fact pattern is set up. You keep telling them, okay, we need to do this. Yeah, I'm going to get to it. Or maybe I can ask the prosecutor. No, I don't want you to do that. Or maybe I can help you with the records. No, I got it. And so this is 30 to 40 hours. We already have one death. How are you dealing with the clock? The clock is ticking. Because it's all about assessing risk. That's a risk. Yes.
To be really harsh about it, I don't think it's the lawyer's responsibility to take care of someone else's family. Like you can, it's like your own problem if you're letting your kid go eat rat poison. Like, why is it on me to get it out of your house? Like,
okay, okay, that's plausible, but are you kind of letting the lawyer off the hook? You're just saying, well,
yeah.
all of these, yes, that's the problem though. And so that's the interesting argument, because you're saying there are other causal factors that the lawyer can't control in these houses. The parents know that this rat poison is in the house and they should take better care, but they may not know that it's industrial strength. That could change some things. Or they may not even know where it is and the child finds it. So there are a lot of different things. What about the lawyer though? How are you dealing with the lawyer and that type of liability? Yeah.
oh, me?
Yeah, Miss Hayes?
No, sharp.
Okay. We gotta get this seating chart. It makes it look anyway, go ahead.
I would do what she said. I would continue to represent.
Okay.
And just like keep urging him to do the right thing.
Okay, well then I'll tell you what happened in the real case in a minute, but I'm worried that you're not nervous really about this time factor. I mean, I think you're getting it right, the confidences and everything, but this the 30 to 40 houses makes me nervous. I mean, even if it was one or two, that would make me nervous, but I don't know. Ms. Harper?
Based on the behavior of the client itself, and you mentioned earlier something about, him not being very smart. To me, that signifies that there is something that's wrong. It could be like he's like me, and he honestly, his brain just keeps forgetting to do it. It may not be that it's not registering how vital it is. So what I would do is, as they've already suggested, like continue to pass the client about it, but also like go with him to these houses and get the rat poison. Because this could be a situation where it's not necessarily out of malice that the client is not acting on what he says he's going to do. It's that there is something mentally that is preventing him from doing it. And it could be that he's just got a really short attention span, he just keeps forgetting, it could be he's zoned out. There's something not right, and I think that kind of plays into the time factor, like why he's letting it go this long.
Okay, any downside about going with him? Mr. Johnson?
I think under the present situation, you as a lawyer, you're not really violating the criminal statute because you're not doing any activity. You're just not doing something. You're not engaging activity, I guess. But if you go with them, then you're kind of becoming more active.
Yeah, it's something. It's not bad yet, but it's. You start working with a client in a situation like this, you could open yourself up to liability. So I don't know about going with Ms. Wagner. Go ahead.
So I would be more proactive.
Okay.
And I would make my continued representation so I can't properly represent you in this matter. But I think going to the houses would probably incite some panic or cause you to have the liability that you would like to avoid in this situation. You might have like a whole bunch of people wanting to sue you and your client by making it more official.
Yeah, and I think you want the client to take the action. So what you said is very practical. That's good. So or urge the client to actually do it. And I think all of you are pointing out this, that the closer you get to sort of assisting the client, then that could open you up for liability. So you want the client to take the lead. That'd be good. Ms. Moore?
I think that if you're working with this client and he's continuing to not cooperate with you in these ways, and the timeline is getting longer, and you're gonna continue to represent him, you need to start paying the fees to cover your own rear, and start documenting, I offer to do this to help, I offer to get his records together, I offer to do this, and here's what I'm working with you. Just to cover yourself when you find it.
So tell me how those records would work that you would keep. That's interesting.
I mean, it depends on, you know, how you typically keep your records.
Uh-huh.
You want to be anything different than what you typically do, but, I mean, if it was really a worry, I would keep the record and have somebody else sign off on them that, you know, if they saw him do this, they wouldn't do this, trying to help. And, you know, warning him what the consequences will be if he doesn't cooperate.
Okay, that's good. That's good. So what do you think happened in real life? This is a real case, of course. So no other children died, so that's really good. The prosecutor finally obtained a search warrant and seized Harry's records. So all of the things you were talking about being proactive, that might have been good if we could have gotten ahead of the prosecutor, but the prosecutor eventually came around and then secured a search warrant and seized Harry's records. Harry then cooperated with the authorities. A government agency went in and visited the home, removed the poison before any other children were exposed. And then Harry's lawyer worked out a plea bargain where Harry was charged only with this single count of involuntary manslaughter, and he was found guilty of that. But Harry's lawyer never really informed the authorities, and it came to a point where he really didn't need to. So that's good. All of you sort of pointing to those things. We were really concerned with the more involvement you get, the more involved you get with your client, your exposure to assisting him with a crime or fraud. And that sort of is a nice segue into our next problem. But before we do that, let's return back to page 116 and 117. This chart of 1.6. Sort of want to go over that in conjunction with what you have on page 135. So this chart is good, but not better than the rule book, but it's good because it sort of points out the scope of this rule that we've been dealing with. So we've been taking it for granted that 1.6a applies. We shall not reveal. But then we have had all of these factual scenarios where we may exercise our discretion. And so we're trying to make a determination about when is it appropriate to do so. And we're seeing that the rule gives us some guidelines, but on some level, it's an exercise of our professional discretion. So when something says may, we won't be charged with a violation if we have the authority to use our discretion. So if there's something that we could do and we don't do it, that does not necessarily mean we're liable. So if you look at Rule 1.6, you notice a number of things. So we have been dealing with 1.6b and the exceptions. We noted that the exceptions are permissive, may reveal. We know that we have the ability to prevent reasonably certain death or substantial bodily harm. Prevent future conduct, that's 1.6b2. So we have a client who may be committing a fraud or reasonably certain to commit a fraud that results in substantial injury. So we can prevent future conduct. So notice that what that means. You can have a discussion with the client, and that is the hope, and you'll be able to dissuade the client from even engaging in this. So we can prevent it. That's 1.6b. I'm just paraphrasing. Lawyer may reveal reasonably certain death B2 is more, I'll just put prevent future conduct. And so notice there's an overlap here. We can't counsel the client to engage in crime or fraudulent conduct either. So we can prevent future conduct, that's 1.6b2. And notice 1.6b3 talks about preventing or mitigating. So there's some overlap there. You might have a situation where there's future conduct, but some conduct has already occurred. So the lawyer does not learn of the client's crime or fraud until after it occurred, and then the question is it ongoing? And have the lawyer's services been used in furtherance of that crime or fraud? So 3 is prevent or mitigate. 4 is to secure legal advice. 5, I'll just put collect a fee. Comply with other law. And then 7 is to, I'll put resolve conflicts of interest. So notice you would necessarily have to talk about some information that is confidential in order to explore the scope of this potential conflict and allow you to comply with the law or resolve the conflict. Now, you can do that effectively by just doing it as a hypothetical. And we're going to be looking at 1.6b2 and b3 when we talk about the problem. Now, back over to page 135. That's the breakdown that you have that we just did, 1.6b2 and b3. And it makes the distinction. 1.6b2 talks about future things that the client plans to commit or is committing. And then 1.6b3 talks about past crime or fraud. preventing or mitigating. And usually in that situation, the criminal or fraudulent conduct is ongoing. So, look on the top of page 136. This will help us make some type of determination. So we have this general rule, and we keep saying this. If you look at the bottom of page 136, a lawyer is allowed to reveal information about client crimes and frauds only if the lawyer's services were used in the perpetration of the crime or fraudulent act. So generally, we must keep these confidences. However, if we determine that our services have been used in furtherance of a crime or fraud, we are allowed to reveal. Now, is that permissive or mandatory? And there's some confusing language here. I want someone to resolve this. Now, the book sort of gives us an answer, but the rule is worded in a weird way. So it says in the middle of page 137, when a lawyer's services have been used to assist a client's crime or fraud, the balance tips in favor of permissive disclosure. But there's some language that is somewhat confusing, and sort of want to explore that. So, if you look at, there's another rule that comes into play here too, and that is 4.1. 4.1 talks about truthfulness in statements. So during our first class, I said there were duties and obligations that we have beyond the traditional attorney-client relationship, and one of those is we have to be honest to people, and we have to be honest in terms of our statements to others and the representations that we make to others. And if you look at 4.1b, there's sort of a tension that I want to discuss. So we said may. This is discretionary. And the reason I'm highlighting 4.1 is that there's a sentence that sort of refers back to 1.6. And I'm looking specifically at 4.1b. And it says this: in the course of representing, and this is going to be mandatory, so I want to figure out how we deal with this. In the course of representing a client, a lawyer, notice this, shall not knowingly and then his letter B. Fail to disclose material fact to a third person. You know, that could be an entity that is relying upon representations that you've made for the client. preparing paperwork, making representations and communication. Shall not knowingly fail to disclose a material fact to a third person. Notice this, when disclosure is necessary to avoid assisting criminal or fraudulent act by the client. Now here's the kicker. This is what. So all of this up to this point is mandatory. Shall not knowingly fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. And we also notice from Rule 1.2D, which talks about scope of representation. Remember, that is the rule that says a lawyer shall not counsel a client to engage or assist the client in conduct that the lawyer knows is criminal or fraudulent. And then it goes on to say that the lawyer can talk to the client about the consequence of proposed actions, but cannot assist in fraudulent or criminal conduct. So we have these rules that say over and over the same thing: do not assist the client in fraudulent conduct. But then we have this little sentence, this phrase that comes after this comma. And even the book says that this is really confusing. But the rest of 4.1b says this: unless disclosure is prohibited by Rule 1.6. What does that mean? So you have a mandatory duty not to assist a client's fraud or criminal conduct. Our services cannot be used to further such conduct. It says you shall not knowingly fail to disclose. That seems mandatory to me. But then it kicks you back down to something that could be viewed as discretionary. How do you explain that? How does it work? So is it, my services have been used in the furtherance of this crime or fraudulent conduct? I have a mandatory duty to disclose, but it's prohibited by 1.6, which means I can keep these confidences. And even if I decide to disclose, it's purely permissive. So these rules don't really mean. What does this sentence mean? The book even says, this is on page 143, obviously this is confusing. So how do we resolve it? Go ahead, Mr. Johnson.
I would think that if something falls under 1.6b, then disclosure would not be prohibited by
Right.
1.6. So therefore,
Right.
that
Go
seems
ahead.
like it would make sense. I mean,
Would not be, but then does it give you a choice though? Because it seems like, what I'm suggesting, it seems like it should be mandatory. You can't help a client engage in crime or fraud by using your services to help the client do so. And it seems like 4.1 and 1.2 say that. You cannot assist a client in that type of fraudulent conduct. But then it sort of shifts back to 1.6 unless disclosure is prohibited by 1.6. How would disclosure be prohibited by 1.6? If we make the determination that this is a confidence, therefore it's not mandatory, and I have the discretion to determine whether or not it falls within one of these exceptions. So I'm asking this, can a lawyer say I don't have to do anything because of that sentence? Disclosure is prohibited by 1.6. So even if I find out that my services have been used in an ongoing criminal or fraudulent act, can you say, well, it's prohibited by 1.6? So I have the discretion not to disclose, even in the face of this mandatory language. What about that? I think that's a drafting problem. We need to sort of figure that out, because you can't leave yourself open. And so this is what I think it means. You have this rule that says you can't assist criminal or fraudulent conduct. I think the discretion of Rule 1.6 is restricted by situations covered by 4.1. In other words, if we know under 1.2 you can't engage in crime or fraud, you have this mandatory prohibition against disclosing client confidences, but you also have this notion that transactions with persons other than the client have to be truthful. It seems that the discretion of 1.6 is restricted in situations covered by 4.1. In other words, whenever a lawyer's services are used in crime or fraud, there is a duty to report. And the book comes close to saying that. For example, look on the top of page 136. How do you distinguish those two examples? You see, the first example says you cannot reveal. The second example says that you may reveal. How do you distinguish those two? So notice this is the point I made. Look at when you're trying to distinguish these two, go ahead.
Something that hasn't happened yet versus something that never happened at all.
Okay, well tell me, you had these two examples on 136. How are you distinguishing them? Cannot reveal the first one, and you said something has happened or something has not happened at all. So what is the? Go ahead.
The client hasn't used the lawyer's services to commit any crime yet, or not even a crime. But in the second example, like not the lawyer or the client is using the lawyer to perpetuate an invented injury. So it's not only are they using it, they are like using it in that present moment.
And your services are being used, so you would disclose. Good. Now, is that disclosure permissive? In other words, do you have the option not to disclose, or is disclosure mandatory when your services are used?
I would think in that situation it would be mandatory, because if you don't disclose, then later on the employer can go after you too because you helped the client by not disclosing.
Now notice, so this is confusing. We know this. But notice what the book says on 143. It's kind of a throwaway sentence, but it sort of illustrates what Ms. Harper says. Notice this. This is sort of at the end of the block quote, talking about comment 3. And it sort of highlights this unless disclosure is prohibited by Rule 1.6. And then the book goes on to say this. This means that in a situation in which a lawyer's failure to reveal will constitute assisting a criminal or fraudulent act, Rule 4.1 now requires a lawyer to reveal the information. So the discretion of 1.6 being permissive gives way when your services are used to perpetuate a crime or fraud. So the book says, obviously this is confusing. 1.6 sort of gives you the impression that you have the discretion. But again, if your services are connected to the crime or fraud, the duty to disclose is mandatory. So there is in the book a discussion after rat poison about Enron and Sarbanes-Oxley. And the point that's being made is that if you are dealing with other law, this is a situation on top of page 142 where disclosure may be required even if your services were not used in furtherance of a crime or fraud. So there are some bodies of law, say you're practicing securities law. Remember what happened with Enron and all of that? There was all of these attorneys who didn't disclose anything, and then there was pressure on the ABA, you better change these rules, and then pushback, and then Congress goes in and does Sarbanes-Oxley. And now that requires disclosure even if a lawyer did not assist the fraud. So notice this, the main thing is this: when you're dealing with other law, the lawyer may be allowed to reveal evidence of a client's fraud even if revelation is not permitted by 1.6. This is an example of some other law requiring revelation. On page 144, and we're going to come back to this in chapter 7, you have a duty, let's do it like this. You represent, your general counsel for NBC. General counsel for NBC. The president is having some problems. Poor business judgment. That's bad, but okay, it's not anything fraudulent. But then there's some allegations that can undermine the president's authority. Some accusations of bias and not looking out for the overall interests of NBC. He comes to you and says, I need some advice. I haven't done anything wrong in terms of the business portion of my job, but this bias thing could lead to other things that will show that I have conflicting interests that may undermine NBC's business vitality. Your general counsel. What do you tell him when he comes to you? Oh, and he starts the conversation by saying something like, we're on the same side, right? We both work for NBC, right? What do you say? This is early. This is like a preview. I know we haven't read this yet, but what do you think? Your general counsel for NBC, what would you tell him? Yes?
I think you have to represent the corporation and not him.
Uh-huh.
So you have to tell him that anything he says,
Yeah.
you have to disclose.
Exactly. That's good. And you probably say, well, we should stop this discussion now. I represent NBC. You work for NBC, but I represent the organization. And if we continue this conversation, you may divulge information to me where our positions and goals will totally diverge, and it would be detrimental to you. And as an attorney, I have to say that to you because I know that you're really unrepresented. I'm not representing you, and he is under the impression that we're on the same team, and we're not. So that's good. And that just brings up a point to sort of emphasize that this general counsel has these obligations. On page 144, we're going to see when we look at Rule 1.13 that the attorney represents the organization and has to protect the organization or entity. Does that by a number of different ways. You try to resolve it within the corporation by moving up the chain. You talk to the level of person who can do something about it. Failing that, You can come outside of the organization and report out. So there's this notion of reporting up. Yeah, I'm talking to you, Vice President. Yes, I'm talking to you, President. I'm even talking to the shareholders, maybe. That doesn't work. Report out. You see that on page 144. Another duty is, and these are duties that may require you to disclose outside of Rule 1.6. So one is being an attorney for an organization. Two is candor towards the tribunal. So we have this prohibition under 1.6, but if our client does something and we can't resolve it, we may have to disclose information. For example, the client, unbeknownst to you, commits perjury. You find out about it, you try to mitigate it, you try to talk to the client. No, I'm not going to change what I said. This is your client talking to you. And then you inform the client that you have the duty as an officer of the court to exercise candor towards the court. So you may have to tell that. Or reveal adverse authority in a controlling jurisdiction. That's candor towards the tribunal as well. Even though it may be bad for your position as officer of the court is an even higher calling, so you have to divulge that to the court. So, let me just set up this problem. This is a long problem, so we're not gonna get to it, but I want you to think about it. And when you see what happened in real life, you're gonna just say, wow. This is gonna be a scenario where Reese's Leases, where the attorneys rationalize their conduct on a number of different levels. I mean, they even had a dean of a law school and a professor of professional responsibility saying everything was okay because all of this conduct happened in the past. The lawyer has the discretion to make a determination about whether or not this is ongoing or not, and you just move on from there. And so this was an actual case. And the case was other people's money, but we want to know, is revelation simply permissive here? That's what we're going to be working through. So notice a number of red flags pop up in this case already. Our firm in this hypothetical makes almost all of its money, more than half of its money, from this business entity. 60% of our firm's monthly receipts. And I guess what really triggers this problem, you look on the middle of page 145. So our role is to draw up all of the paperwork. So notice truthfulness and statements to others. We do all the paperwork for this entity, send it out to banks for loans. And we are just affirming Executive Leasing Services owns these cars that it's leasing. Occasionally the firm negotiates leases between companies and corporate customers. And then at some point we noticed that there are really heavy discounts that seem to be weird. At some point we noticed that Executive Leasing Services was charging 15% less than other firms were charging on comparable cars that were leased. Also we noticed that income from these leases often were less than payments that had to be made on the bank loans. And we wonder, why is the bank continuing to loan money to a company that is losing money? We talk to our client, and unfortunately we find out that our client is engaged in advancing counterfeit leases for fictitious transactions. So they're phony leases that make the business look a lot bigger than it is, and the banks keep loaning money. The money keeps rolling in. And you see this attorney is hearing all of this, and he says wow about 2 or 3 times. And so he's trying to discuss how to handle this. He learns that the leases are fraudulent. They wait until everyone leaves the building, and then late at night they have a glass desk. They shine a light through, and then they add numbers to the leases and forge the names on there to create new leases. So it looks like they have old leases, and the old leases are sort of multiplying to new leases. And we say, wow, again. And then we fill out the leases and send it to the bank. Now the attorney's getting really worried. Look at the top of page 147. Hey, and this is us. You say, hey, wait a minute. We signed all of these letters attesting to the validity of these leases. We're talking to the banks. Everything's fine. We've reviewed it. This is our opinion of the financial fitness of our client. And then our client says, this is paying your mortgage as well as mine. Of course, I'm telling you this in the strictest of confidence. Don't tell. This is attorney-client advice. We say, I can't believe you're doing this. I wrote opinion letters attesting to the validity of all of these leases that you submitted for your bank loans. Now, we know we're in real trouble now because the client gives this literal formalistic explanation to us. No, actually, your letters just say that the leases that we use as collateral were genuine, just that we had title to the cars. Yeah, we have title to the cars, so you're not really lying. Just that we had title to the cars that we bought with the money that we borrowed, which was true. You do have title to the car, but notice what the client is doing is just taking a small portion of those facts and emphasizing it. Your nose is clean. Now, us as attorney tells our client this is risky, this needs to stop. All of us could be in jail for a very long time. The client seems to get the message, says we won't do it anymore. We started to think about this anyway, and we're not going to do this anymore. And the attorney thinks for a while, and he says, I guess that might be the best we can do for right now. So the attorney tells the client to stop. The client says, we won't do it anymore. And so now we have a decision to make. So look at the bottom of page 147. Do we reveal the fraud to the bank or the district attorney? Do we not reveal the fraud under 1.6? Or do we not reveal the fraud? Keep in mind that this is 60% of our business. We don't reveal the fraud, and we're just careful from now on. We stay late after business hours to make sure no one's around, check all the drawers and everything, and just make sure file cabinets, make sure everything is going fine, and we continue the representation. So this is going to allow us to look at 1.6 and make a determination about whether or not it's permissive. So one of the first questions we're going to have to resolve is the attorney's services being used in furtherance of the client's fraud? And we'll talk about that. So we'll pick up there when we come back. That's the problem we'll look at. And then we're going to finish chapter 3 and go into chapter 4. Have a good weekend.